Good day, Madam Yusnita. To start off with our topic of understanding professional misconduct, we would dive into the definition of professional misconduct first, where it can be illustrated in the case of Myers and Ellman, where in the facts of this case is that a solicitor is the respondent and he had left the conduct of a certain case he was doing in the hands of his managing clerk, who is not a solicitor. So then the plaintiff applied that the respondent should pay for the cost of the case since that he had committed unprofessional conduct. So the House of Lords held that the solicitor in this case is guilty of professional misconduct, where as a solicitor and the officer of the court, he could not escape his responsibility to the court for the proper discharge of his duties to the court, where in this case, the solicitor delegated them to the managing clerk who was not personally amenable to the jurisdiction of the court. However, it is stated that in Section 94, Subsection 3 of the Legal Profession Act 1976, it defines misconduct as a conduct or omission to act in Malaysia or elsewhere by an advocate and solicitor in a professional capacity or otherwise which amounts to grave impropriety and includes a wide range of acts that is stated in subsection A to subsection O. So from this section, it can be seen it is not exhaustive as the section uses the word includes, which means it could not possibly list out every single misconduct that an advocate and solicitor may commit during the discharge of his professional duties. So therefore, from the case and the section mentioned, a solicitor and advocate who is an officer to the court commits professional misconduct when he is unable to discharge his responsibility in a professional capacity that would seem to be indecorum. That is all for me. Thank you.
Good day, I wish to Madam Sunita and my fellow classmates, my fellow roommates who are to watch this video. So my name is Alif and I'll be talking about the second part of this presentation. So within a capacity of a bar council, of the bar council themselves, they are the regulatory authority for all advocates and solicitors in Peninsular Malaysia and bound by the Legal Profession Act. From time to time, they have issued this ruling in order to maintain the fundamental principles required in preserving the professionalism, integrity, dignity of the legal profession. So, back to our question, what is a legal misconduct? It is a broad of range of acts and circumstances. It covers a lot of it, and the example I'm about to give is not exhaustive, such as anything that contravenes the Legal Profession Act or the rules and rulings made under that, dishonesty or fraud, being found guilty of a crime or convicted of a serious offence, charging manifestly excessive fees to the client, or breaching stakeholder duties. So I'm giving two cases as an example. The first case is Izam Kamal bin Ismail and Prestige Bestari Sundar Bahad. In this case, the appellant, an advocate and solicitor, had acted for the respondent in a sale and purchase agreement. In his capacity as a solicitor, the appellant had received the sum of 300,000 ringgit, which was to be held by the appellant's firm as a stakeholder for the respondent's company. It later transpired that the appellant had erroneously released the monies to his clerk, who was primarily responsible for the running of appellant's firm. As a result, the firm was unable to pay the money to the respondent. Upon discovering this error, the appellant lodged a police report against his clerk, and the respondent themselves lodged a complaint against the appellant towards the Bar Council Disciplinary Board and recommended that the appellant to be suspended for 3 years and fined for 10,000 ringgit. The Disciplinary Board concurred with the findings, and the appellant is to be struck off the role of advocate and solicitor. So moving on to another case, this is quite a simple case. The appellant was serving as a magistrate and he was charged on 2 counts of accepting gratification punishable under the Prevention Corruption Act. Honourable mention to this case is that the Act has been repealed and replaced by Anti-Corruption Act 1997. In conclusion, there are 2 common cases and acts, including the Anti-Corruption Act 1997, that governs the act of professional misconduct of an advocate and solicitors. Like I mentioned earlier, lawyers are expected to commit to their duties bound by these laws and ethics, conduct in matters of practice to maintain the fundamental principles in preserving the professionalism, integrity, and dignity of this profession. That will be all from me. Thank you.
Hi, my name is Amai Dayat. I'll proceed with the types of professional misconduct under the Malaysian law. This could be found under Section 94, Section 3 of the Legal Profession Act, which lists down other categories of misconduct by an advocate and solicitor. Firstly, I would like to start with breach of duty with regards to undertaking under Section 94, Subsection 3B of the Act. This breach of duty includes any breach by a lawyer to the court. So the reason of this subsection is to ensure smooth and efficient administration of justice. And a breach of duty is seen in the case of Home Office and Harriet Harman, where the solicitor was charged with breaching of duty by giving journalists access of the Home Office document, which is not allowed as it was revealed to her as in her capacity as a solicitor in the course of proceedings. Secondly is on subsection C, which is on dishonest or fraudulent conduct in the discharge of his duties. A clear example could be seen in the case of Chung Yik San and Majlis Peguam Malaysia, where in this appeal case, the appellant had withdrawn money from the client's account to cover medical bills for his late wife. He, however, did eventually repay the sum of 16,950 ringgit to the client. Furthermore, he submitted that his act was neither intentional nor fraudulent, and the court dismissed the appeal and held that the withdrawal and utilisation of client's money, notwithstanding the circumstances under which the acts were committed, were nothing short of dishonest and fraudulent conduct within the meaning of Section 94, Section 3C of the Act. So although he did repay back the amount, it makes no difference to the fact that his initial action was certainly illegal, and as a result he was struck off the role as an advocate and solicitor. Thirdly is on breach of any rules of practice and etiquette found under Section D of the Act. Other than this Act, an advocate and solicitor should not breach any provision in Legal Profession, Practice and Etiquette Rules 1978. Lawyer must act with all due courtesy and fearlessly uphold the interests of his client. In the case of Lim So Hua and another and Wong Sin Chong, where the advocate and solicitor was liable for negligence, it was held that it is a fundamental duty of a solicitor to keep the clients informed of dates and prepare the case with the client. Furthermore, it is the advocate and solicitor's duty to exercise reasonable care and skill, which is imposed both by the contract and by the law of tort. Fourthly is Section 94, Section 3E of the LPA, where a solicitor is educated of a bankrupt and guilty of any act under paragraph 33 of the Bankruptcy Act. Under the Malaysian Department of Insolvency, a person is declared a bankrupt pursuant to an education order made by the High Court against the debtor if he is unable to pay his debts of at least 100,000 ringgit. In the case of Dashan Singh Khairap and Majlis Peguam Malaysia, the appellant had assisted the complainant with a practicing certificate as he was a bankrupt. After the complaint was heard by the Disciplinary Committee of the Malaysian Bar, he was found to have committed a serious misconduct by providing legal advice without a valid practicing certificate. So in this appeal, he maintained that as a layperson, he was merely advising a party and not practicing law. Held the appellant as an authorised person, not only actively advised the complainant, but he also had prepared documents to be filed with the complainant. Thus, as bankrupt falls under professional misconduct, they may not assist another party in their own legal case. Fifthly is the tendering or giving of any gratification to any person for having procured the employment in an illegal business stated under Section F of LPA. What this essentially means is that any action of offering, giving or soliciting something of value to influence the decisions of the lawyer is a misconduct. Quoting back Lord Wolf in Attorney General against Blake, the employee must act in good faith. He must not make a profit out of his trust, and he must not place himself in a position where his duty and his interests may conflict. That's all from me.
Hello, my name is Muhammad Shazwa Aziz bin Muhammad and my ID number is 11811011134. So in my part, I'm going to continue with the type of the professional misconduct by the solicitor and advocate from where my previous groupmate had left off. Firstly, it's about touting, which is mentioned in Section 94, Section 3 H of LPA. Touting for client is like advertising. It is inconsistent with the interest of the public and honour of the profession. The function of solicitor is to advise or negotiate or argue on behalf of the client, but only if retained. The client may seek him, but he must not seek the client. Furthermore, permitting unauthorized person to practice law, which can be referred in Section 94, Subsection 3I of LPA. The trust and confidence of the client should not be allowed to be delegated. It is prohibited to set up a firm with unqualified person as a partner. As example, allowing clerk to undertake and carry on legal business in the solicitor name, or to authorizing an unauthorized person from operating any bank account in the name of solicitor of his firm. We can refer in the case of Myers against Elman, which is in this case solicitor, he could not escape his responsibility to the court for the proper discharge of his duty to the court by delegating them to a managing clerk who was not personally amenable to the jurisdiction exercised by the court. Additionally, carrying on incompatible business, which is stated under Section 94, Subsection 3J of LPA, will be liable to disciplinary action if the lawyer carrying on in his employment any trade business that detract from the profession of law. Lawyer who has professional cooperation may not involve in any business. As to illustrate, we can refer to the case of and advocate cases that a solicitor also active in selling women clothes during carrying law practice, which is not allowed. Under Section 94, Subsection 3I of LPA, a person who has been disbarred or guilty of misconduct in another country is also considered to be committing professional misconduct in Malaysia, barring the person from practicing here. For example, if a person is charged under Section 70 of South Australia Legal Practitioner Act 1981, which is similarly on conduct capable of constituting professional misconduct and is disbarred, he should not be able to practice in Malaysia. Finally, under Section 94, Subsection 3 of LPA, any person found guilty of conduct unbefitting of an advocate and solicitor or which bring or is calculated to bring the legal professional into disrepute. We can see in the case of Dato' and Canvas and another against Bar Council. In this case, the issue was whether the breach of stakeholding term was only a mere breach of contract that can be remedied with damages or amount to misconduct. The court held that mere civil liability instances such as breach of contract would not amount to misconduct. Nonetheless, a breach of contract with element of contravention of professional rule is misconduct. The court further held that the relationship between the stakeholder and parties in the transaction is fiduciary in nature, and the breach of duty as stakeholder is a breach of duty as trustee. Therefore, beyond argument that the breach of stakeholding term is breach of trust and the failure of honour such term and duties is prima facie evident of professional misconduct.
Very good day, madam. My name is Amir of Bencik Ramlan, and for my part, I'll be doing question number 5, which is to explain on the consequences of a professional misconduct in Malaysia. Now, under Malaysian law, misconduct is committed by an advocate and solicitor if a particular act or omission falls within Section 94, Subsection 3, Para A until Paragraph O of the Legal Professions Act 1976. Now, the consequences of such acts or omission falls under Section 94, Subsection 2 of LPA, which states that any advocate and solicitor who has been guilty of any misconduct shall be liable to one or more of the following penalties and punishments. Now, these penalties includes A, to be struck off the roll, B, to be suspended from practice for any period which does not exceed 5 years, C, to be ordered to pay a fine not exceeding 50,000 ringgit, and D is to be reprimanded or censored. Now, we can see these consequences in a few cases as an example. For example, in the case of an advocate and solicitor, the court recorded a censure and ordered the respondents to pay costs as the solicitor had prepared an affidavit that is untrue and that is known to him to be untrue. Now, the court has held that this is to be a serious offense. Furthermore, there are also some reported cases that shows that an advocate and solicitor may be found guilty for misbehavior and improper conduct in court, which could lead to an offense of contempt of court. Now, this can be seen in the case of Kumanendran, an advocate and solicitor, where in this case the counsel was defending an accused person charged with an offense under the Corrosive and Explosive Substance and Offensive Weapons Ordinance 1958. Now, the defense counsel was shouting at the witness and had failed to conduct the case with decorum and proper manner. The court then ruled that the advocate had committed contempt of court and committed the advocate to 2 days imprisonment. Another example is in the case of Titi Raja, where in this case the respondent, who is an advocate and solicitor, used grossly offensive and improper expressions and threatening gestures to the defense counsel. Now, the respondents had called the DPP, who is a government agent, a running dog, and the court a police court, an organ of power. Now, the disciplinary committee found the respondent's conduct in court to be professional misconduct and ordered that he is to be suspended from practice for 2 years. Now, these are the couple of examples that I've given to see the consequences of what might happen to a lawyer if there is a professional misconduct involved. That's all from me. Thank you, madam.
To put it in a simple conclusion, professional misconduct is when a solicitor and advocate is unable to discharge his responsibility in a professional capacity, where they are to perform their duties bound by the law and ethics conduct during practicing to maintain or clarify fundamental principles required in safeguarding the professionalism, integrity, and dignity of the legal profession by avoiding different types of misconducts that are including the one that is stated in the statutes that my previous groupmate had stated before. So in which solicitors and advocates who fail to do so to avoid these misconducts would be liable to penalties. That is all from our group. We say thank you to Madam Yusnita for watching our video, and that would be all.